is Wednesday, February 11th. This is joined by Legislative Council. Hello. Good morning. We have a new draft of S325. At least in part related to things that we heard yesterday. Though just to frame this, so I'm sure you have as well, but I certainly have been hearing things about how implementation of Act 181 is going. And it seems as though there is an opportunity to, as with any major bill, do some tweaking, course correcting in terms of trying to hold to the vision of what Act 181 was intended to do. And so this draft that we are looking at is intended to do just that, to look at places where maybe we could use some more time, places that were maybe ambiguous that could be clearer, and as things are playing out, make adjustments so that hopefully we can do both things of building more homes in places where we know it makes sense and protecting the environment, especially the places that are sensitive, critical natural resources. So that's sort of what leads us to the intent section. And I also want to note that there are things in this draft that we might want to continue to examine and tweak. And there may be things that are not in this draft that we may want to bring in. And so this is a starting point. Okay, having said all of that, we turn it over to Legislative Council.
Ellen Tchaikovsky, Office of Legislative Counsel. So, yes, I'm here on a committee amendment to S325. You saw S325 as introduced last week in your committee bill. That was about a study committee related to model bylaws. The amendment you have today is draft 1.2 dated 2/10/2026. That language is not in here. This is a strike all that replaces all of that language with, like, as Senator Watson just said, language regarding Act 250. So section 1 is an intent section. The General Assembly finds that 2024 acts and resolves for 181 represented a substantial restructuring of Vermont's land use review framework. This act is intended to provide technical clarification, transitional certainty, and implementation alignment consistent with the intent of 2024 Act 181 without altering its underlying policy goals. Section 2 starts amendments to Act 250. So the first couple of changes are related to the dates in the interim housing exemptions plural. So but first on page 2 is the road rule. What has been called the road rule, but is actually a jurisdictional trigger under Act 250 related to the construction of private roads greater than 800 feet. The change technical. There once was a road rule that is gone. It's been reincarnated as a law. On page 2 is the first change. So currently, as it was enacted in Act 181, the length of the road construction, you don't begin the jurisdiction under the road rule until July 1, 2026. So roads constructed after July 1, 2026 may be subject to this jurisdictional trigger. The language on line 4 pushes that back to July 1, 2027. Further down is where we do start to see the language regarding the interim housing exemptions. So the first one is regarding priority housing projects. So currently, there is an exemption for priority housing projects under Act 250. If they meet the qualifications in this section, any number of priority housing projects are exempt from Act 250 until currently January 1, 2027. This does a couple of things. It pushes the date back until June 1, 2027. And then it adds, it's the construction of priority housing projects or related subdivision located entirely within a designated downtown neighborhood development area or growth center. And areas with permanent zoning and subdivision bylaws that have been mapped as downtown centers, village areas, or planned growth areas. Or within a 1.5 mile around such designated center with permanent zoning and subdivision bylaws served by public sewer and water services or soil that are adequate for disposal. So,
Oh, yes, sure, yep.
well, I was going to explain it, but go ahead.
Okay. No, go ahead.
Well, so this is the proposed language I was given, so. Currently, the definition of priority housing project needs to be an affordable housing project built in a designated area. There are new designated areas they're transitioning from the old designations to the new designations. This is also adding though that PHPs can be in mapped areas, using the terms under the future land use maps. Downtown centers, village areas, and planned growth areas. It is unclear to me, I don't know how divergent that is from the existing map, from the existing designated areas. To some extent, they should be, I don't know. And the existing definition of priority housing project should maybe be altered. Also, this is just the jurisdictional trigger, so if you will have to make decisions, I think, in the future about the definition of priority housing project regardless. So you may want to think about that too.
So on line 13. What is related subdivision?
I didn't draft this language, I just, so I think it is referring to that, when you're going through the development process, you may need to subdivide lots in order to create housing. And so the subdivision of land can trigger Act 50 if it's more than 6 lots or more than 10 lots. So I think this is looking to have an additional exemption from subdivision.
So it's related subdivision for the purpose of affecting the height of the house, whatever the house is like. Okay, that's it.
That's,
Okay, so let's just, okay, you don't make that.
Yeah.
Okay.
It's related subdivision or.
yeah,
So let's then make sure we understand what the next work means, that when we starting with line 15. What are we actually doing? Or are we really saying that in addition to the existing areas, once the maps go in, they go into effect, they'll downtown centers, village centers, which are like others will be treated as if they were one of these areas.
So this exemption is intended to sunset when those maps take effect, so I don't know I don't know about this language, you'll need to hear.
I think you might, yeah, we have people who can speak. Yeah.
Okay. Next on page 3. There was just a typo on line 3 that's being fixed. Section 3, still within the exemptions, but a different aspect. So 10 VSA 6081 is one of the exemption sections for Act 250. So language was added in Act 181 that is being struck at the bottom of page 3. So upon receiving notice and a copy of the permit issued by the appropriate municipal panel under 4460G, a previously issued permit for a development or subdivision located in a tier 1A area shall remain attached to the property. And so you will recall that areas that have been designated as tier 1A status will have a full exemption from Act 250. Part of the review to determine if they should be tier 1A is if the municipality has robust zoning bylaws that are somewhat akin to what the criteria review under Act 250 is. So the municipality is taking over the review of the development. The question came at that when we were working on this of what happens to the existing Act 250 permits since they are under statute, they exist in perpetuity. So what happens if Act 250, if a whole area is exempt from Act 250 jurisdiction, this sets up in this section and then in 4460G that the municipality will take over the the enforcement of the permits and permit conditions by virtue of being in charge of the municipal zoning permit. Language was added here that says neither the board, the land use review board, nor the agency of natural resources shall enforce Act 250 permits or assert amendment jurisdiction on land unless the designation is revoked or the municipality has not taken any reasonable action to enforce the conditions of the permit. So this was setting up that if there was a tier 1A area, A&R and the LURB have no jurisdiction anymore, they can't do the enforcement, the municipality is in charge of enforcing permit conditions. This is getting rid of that to have LURB and A&R still do enforcement of Act 250 permits in these areas.
It's good.
But until,
No, it's being struck.
okay, so
Oh, until what?
until there's a permit.
Until there's a permit amendment. So the language in 44G, which we're gonna talk about in section 5, is on page 7 in section 5. Is there's a process in 4460G that sets up that when a municipality makes an amendment to a municipal permit, they are to incorporate the existing Act 250 permit conditions into that permit so that they can enforce them. That language is remaining. This is about the between and in between sort of until that happens and the municipality incorporates the conditions. A&R and the board shall still have enforcement authority.
Thank you.
On to page 4. So these are the rest of the interim housing exemptions. And I guess I do want to, well, interim housing exemptions are in DD, but there's just 2 other temporary provisions under Act 250. So the first one, there's a temporary exemption for the construction of 1 accessory dwelling unit for a single family home, and that under this bill is currently that expires July 1, 2028. The dates in this bill push them all out 6 months, so that would be January 1, 2029. And then same for the next one, CC, which is for converting a structure used for a commercial purpose into 29 or fewer housing units. Till January 1, 2029. I don't know if you want, I'm just gonna point out that all of the dates in this section are different. So you may wanna, and these 2 are not in the other section, so perhaps they are different and have different issues you want to consider.
Sure, yes.
Can I just add, this is all very confusing the way that this is playing out.
Sure.
I don't, I mean, whose language is this? And where did it come from? And why are we doing this now? Before we actually got testimony on all the questions that were raised yesterday and some backstory of how we got where we got. This is just really confusing.
Sure. Yeah, no, that's fair.
And it makes me really uncomfortable to have our attorney say, she didn't draft this language, I don't know where this came from, so who's drafting the language that we have in front of us?
Sure, so it was a collaboration of a handful of stakeholders. So some we're gonna hear from in next section, so including the chamber as well as the university.
Okay,
Yeah.
it would be great if the committee could actually draft language and sure stakeholders and lobbyists. Thank you.
We're gonna keep going for now,
Yes.
and then we'll hear more. Yeah.
So on page 4, the interim housing exemptions, this first one in subdivision 1, this is for, the construction of 75 or fewer units, within a new town center, growth center, or neighborhood development area. That's being pushed out until January 1, 2028. Onto page 5. The development of 50 or fewer units of housing. When located in a village area and within 1/4 mile around it, it has permanent zoning and subdivision bylaws. Or areas within the census designated urbanized area with over 50,000 residents and within 1/4 mile of a transit route. That is being extended until January 1, 2028. It's also adding that similar language is required for the subdivision. Or the construction of housing projects and mixed use development. The next one at the bottom of page 5, again, still for interim housing exemptions. So these are for those that are located within a downtown, so there's no cap on the number that can be constructed in a downtown. That will be exempt. That's being pushed out to June 1, 2027. And it's for the subdivision 4 or the construction of housing projects and mixed use development in downtowns. So next on page 6, the tier 3 rule making. So in Act 181, the tier system was created, tiers 1A and 1B, and then tier 3. Tier 3 has a rulemaking process for the land use review board to work with A&R to define what is included in tier 3. The date for the finishing of those rules is being pushed back, because currently in statute, it's currently in this provision, it says that they need to submit the proposed final rule to LCAR on or before February 1, 2026. It's being pushed back to 2027. And it's fixing the name of the committee. On page 7, so the language on page 7 is section 5, 24 VSA 4460, which I was already talking about. So subsection G says of this process for municipalities to go through when a development already has an Act 250 permit and they're needing a municipal permit or an amendment to a municipal permit. This goes through the process that they need to use to determine if the Act 250 permit conditions need to be transferred to the municipal permit. That language is not changing in G, but it's helpful context for the change which is happening on page 8, which is striking H. And it relates to what we already saw previously, which is currently H says in a tier 1A area, the appropriate municipal panel, so usually the development review board or whoever structures, whatever structure they're using to issue permits, shall enforce any existing Act 250 permit that has not had its permit condition transferred to a municipal permit pursuant to subsection G. So as we discussed, it's getting rid of this provision that's the municipality is taking over. Municipalities now under this bill taking over enforcement after there has been an amendment.
Yep. Thank you.
And then on page 9, section 6, tier 1A area guidelines. You may need to hear what the actual proposal is here, but the land use review board did issue guidelines for municipalities to follow when they're making their application for a tier 1A area. This is adding language that says on or before October 1, 2026. The land use review board shall update its tier 1A area guidelines to set procedural standards to ensure consistent application of requirements across municipalities.
Do you want me to comment on them?
Do you have something to add?
Well, I think we one of the things that we may want to hear about is how the consistency has been going, in terms of, the application of the creation of, tier 1A maps. If there may be some need for that.
Section 7 is changing effective date from Act 181. So currently in Act 181, sections 12, 13, and 21. Those take effect at the end of this year, December 31st, 2026. They're being pushed back to July 1, 2027. Section 13 is the new criterion forest blocks and habitat connectors. That is being pushed back. And so section 12, which are the definitions associated with that section, also being pushed back. And section 21 is the section that establishes the tiers. So that's also being pushed back.
Where are we?
I'm on page 9, section 7, line 8.
I see section 12, oh, and 21.
Can you just say again what section 12
That
and
is the
13?
definition section associated with forest blocks and habitat.
Okay. And 13?
Is the new criterion 8C for
Yep.
forest
Okay.
blocks.
No, compact development, cluster housing.
Be sure,
21.
is the jurisdictional trigger for the new tiers.
It's all getting pushed back.
Yes. Line 10 into 11. This is section 19 is the road jurisdictional trigger. It's currently set to take effect July 1, 2026. This is being pushed back to July 1, 2027. As with the section earlier, Bill. Next, on page 9, section 8, tier 1B appeals report. So on a report January 15th, 2027, the Land Use Review Board, after consultation with the Vermont Association of Planning and Development Agencies, the Vermont League of Cities and Towns, the Vermont Natural Resources Council, and the Vermont Planners Association, shall report to the General Assembly on recommendations for how to limit the number of appeals of municipal zoning permits that can be brought against housing projects located within tier 1B areas. The board shall identify mechanisms for limiting appeals that allow municipalities to address legitimate concerns with the project. On to page 10. The report shall also identify the most commonly raised issues on appeal, evaluate statutory or procedural tools to limit duplicative and non-material appeals, and recommend legislative action needed, if any. The report shall be submitted to the House Committee on Environment and the Senate Committee on Natural Resources and Energy.
So one thought about this section is that it is thinking about where this bill started as the Let's Build Homes proposal, that was one way to think about limiting appeals, and this is just broader than that, to speak about what are options that we might have in terms of limiting appeals.
And we just got this report, we just got a report from them about appeals.
It's so I guess I'm thinking about that report as about transferring the process for appeals for Act 250 to the LURB. So this is, thinking about other options like certificates of compliance or pre-approved kind of like the 802 homes models where certain aspects are pre-approved and so not appealable. There's other options. So it's looking at potentially some other options for limiting appeals.
Okay. Section 9 is the effective date, takes effect on passage. And then finally, I am on page 10 of the title of this bill will change after passage to an act relating to Article 50 tier jurisdiction. Or something else. To more match what's going on with it.
Great, thank you. All right, super. I'm sure there's still lots of questions. And we'll just unpack it. So thank you so much. All right, and we're gonna move on to hearing from Megan Sullivan from the Vermont Chamber of Commerce. Welcome.
Good morning, Megan Sullivan, Vice President of Government Affairs for Vermont Chamber of Commerce. Thank you for having me back 2 days in a row. So yesterday was sort of high level, written remarks on what we were seeing out there and what we were hoping for specifically on the extensions of some of the timelines. And so I want to dig in a little bit more. I will say, we've been collaborating for 3 years now on this process and continue to collaborate as the stakeholder process move forward and work with other folks to say like, all right, massive bill passed, changed a lot in the last few weeks, expected that we're going to need some tweaks as we're going through. What are some of those tweaks that generally different perspectives can agree on? Sort of put those on paper. I will say, I don't think we drafted the language, but just drafted ideas of here are some things we work on. I am not a lawyer and I don't even intend to draft legal language or I was just going to talk about some of the areas that we really see as important, and I think some of this language addresses it, and then some of it maybe we needed to be a little bit more clear in what we were actually trying to get at. So the first piece on extending the interim exemptions. Is just make my put my reading glasses. So, and I think this has to go hand in hand with looking at, what's going on with the applications for 1A and 1B, and I think there's, bringing communities in, whether it's the LCT. Let's Build Homes was very active in the sort of guidelines around 1A, so bringing some of those groups in to say like, what are we seeing? What are maybe some of the limiting factors? And do we need to address them, right? If we're not seeing as much uptake on these exemptions as we thought, why is that? And what do we need to do? And extending those interim exemptions out in recognition that we have a housing crisis, and for better or worse, Act 250 is a limiting factor reputationally. People try to avoid it. And so if there are folks who are saying, we want to get 1A, but we have to get our ducks in a row to make sure our town meets all the criteria, and that's going to take longer than this initial timeframe, that we have those interim exemptions longer, so that while that work is getting done, those communities are still accessing that exemption, so those housing projects move forward. Senator Hardy, yesterday you asked like, what's that struggle between the extension, and I think part of it is things might be getting planned with the anticipation that a community was going to have 1A, so like, well, we've got the interim exemptions now, and then there's going to be 1A, so they'll be exempt anyways, and if that community is not going for 1A, it creates this, okay, well, we thought we had certainty and now we have uncertainty. Should we move forward? Should we not move forward? I think if there's that date that said, by 2030, we're gonna know, like, is the community just saying we don't want 1A or it's gonna take us time? We're gonna know that in advance enough for a housing project that takes years in Vermont to get done. We'll have some date certainty to plan for. That's our intention there. Again, I think bringing in some of the folks to talk about what's going on with applications for 1A and 1B is important to hear more about that, but that I think is why we would like a date closer to 2030 than what's in the draft before you for that, but that's our rationale.
It just seems like anytime just pushing the date out unless there's other criteria in there is not going to create certainty, I don't think. Because what happens with these things?
Nothing ever sunsets Monterey.
And people will come back again,
Yeah,
and be
no, I
like,
hear
oh, we
you.
have another project that's stranded, we need to push the date out, and so I'm really skeptical about those kinds of things unless. I mean, I understand,
Yeah,
and I also think just pushing the date out isn't gonna give the certainty, I would rather be like, okay. These are the things that you need to do, these are the things that are gonna happen, these are the things you need to do, and this is the deadline, you know? And then a deadline is a deadline, and I mean, I'm all for trying to create flexibility in the extension, but just extending a date. You're gonna be back here, I guarantee it. You're gonna be back here next year asking for.
I mean,
thing.
well, definitely be back here next year.
Or
Yeah.
in 2 years. I've been here long enough, so I know people, I could list the,
I
you
know.
know, and so that's what I wanna.
Well, and I think that second part, I would agree, is incredibly important. It's not just about extending the date, but also giving that information of like, okay. When we did this, we thought communities were going to want to be a 1A community, want to be a 1B community. And if now that we're in it, they're like, no, thanks, like, what is the reason they're saying no, thanks? And how do we address that? Or do we not address that? Is that sort of like, okay, well, I guess our communities really don't want this. I think we are in a housing crisis, so I don't think it's inappropriate for the state to say, in the next 3 years, we're gonna say, like, housing can be built there, whether you like it or not, though there's a lot of other levers comes out to push back on that. But we need to get a little bit more information about what is happening, people not wanting to, communities not wanting to opt in, and is it we need to support them better, or is it just don't want it?
Yeah, and I think that's 2 different issues, the stranded projects and the wider communities not wanna be tier 1A and tier 1B.
With the exception of, I think there could be projects that are getting planned because they're anticipating, well, obviously, and I don't wanna pick on any town in particular on the record. Obviously that town, city would be a 1A area, so we can be planning a project, knowing the exemptions are in place now, and if it takes us years to get there, the exemptions will be in place in the future. Finding out they're not gonna be 1A. So we're not gonna be exempt, well, what do we do?
So maybe it's a big language about projects that have started in this time period.
And what that start means, like.
What the start means and then when the end date is, not just pushing the date out.
I think there's, not that I wanted to work for Alan. I was just doing anyway.
I mean, this is why, like, the committee working on the language together is preferable, because then we can work out the language and.
No, I
hear
think
what
this is
you want,
important
and then
conversation.
we figure it out.
Yeah. But I. Not.
Yeah.
Well, and I hear you, and I'm hoping that this could be a place to start.
And if there's, once a community, if they get that 1B status, if they get that 1A status. Is there a way, and maybe that's more appropriate in rulemaking than in lawmaking, to say, once you have it in place. Like these interim extensions of. Gone away, in case orders don't line up or whatever it is, if there's. Say, it's until this date, or when your community has an approved map. That really is challenging to me, but just throwing it out there. I'm gonna talk about priority housing projects a little out of order, just because I think it's more pertinent to this, but. The priority housing project conversation is related to that 1B in that. We certainly hope that communities are not saying. We are going to avoid 1B because we don't want affordable housing. In our communities. That's not the rationale for saying we don't want 1B. Priority housing projects have been a game changer for being able to build affordable housing in. A lot of different types of communities, and so. Continuing to allow that incentive, even if a community says we don't want 1B. It's important to say, okay, well, if you're making that choice not to have 1B. priority housing projects are still gonna be allowed. Incentivized around Act 250. So I think the intent around the priority housing project language was less about what is the date of priority housing projects and more just saying. If a place is mapped for a 1A or 1B and they choose not to. Move forward with that designation, that priority housing projects can still be applicable in those areas. So that this isn't about saying no to affordable housing.
We should create 1C, I think it is calls for their tier.
Okay, right, that's a great thing, here we go.
What B2?
Yeah. So that was the thinking behind what the proposal was around priority housing process, just making sure that. Affordable housing continues to be allowed, in communities, because that has been a game changer. On the dates for tier 3, and the road roll, specifically, you know, I think members of the land use review board, may not feel like they need an extension for those, right? That, they're on track for the dates that are in there. What I think is critically missing and maybe is causing some of the higher anxiety around tier 3 and the road rule. When we were in these committees in 2024, a lot of the conversations, I shouldn't say a lot, there were specific conversations that if the only trigger was one of these new things, if the only trigger was an 8C trigger, or the only trigger was the road rule, so you built something that otherwise would not be an Act 250, but for the length of the road. Do you need to go through 32 criteria? Because it's extensive to go through that 32 criteria if the only thing is the length of the road, and the road is really about forest fragmentation and wildlife. The idea was that land use review board would be able to, in their rulemaking, say, here are the criteria, if that is the only trigger that you need to look at, which takes a lot of the pressure off of going through activity as this sort of beast, right? That it's, all right, we just want to check these 2-3 things because this is what's gonna be impacted by this development, and we want to see if we can do it in a way that really is more harmonious with our natural resources. My understanding is land use review board's attorneys said that is not what is in the language, that they can't do that type of limiting those factors. So even though most of the folks I talked to, that was the understanding of the legislative intent, the land use review board is saying, based on the language, we can't actually do that. I think that is an important conversation to have of saying, if that's the only trigger, right, if it's a major development that like 17 things, or the reason it's an activity, you've got to go through the whole process. But if it's just that one thing, how do we limit what needs to be done to ensure that we're reviewing things that are important to review, but not saying, okay, those 2 houses would get a study on what is your impact on traffic, get a study on what is your impact on schools, get a study on what the impact on the communities. 2 houses is unlikely those things are really going to be impacted. How do we limit it? And I think clarification for the land use review board that they can review those things is important, and in doing so, that's going to take time, more time that we have in the current deadlines, and so an extension in order to do that work is important.
And if I might add, that idea to clarify that the land use review board has that ability is not in here.
Yeah.
And I think I will just flag it's something that I think we might want to add. But yes,
I actually have a question for Senator Baumgart, because we've been doing this longer than any of the other rest of us. Was that the intent? Was there at some point some kind of list of things?
I can't remember, but I wanna look at the language that we passed, see if it doesn't apply, and it should be this public again. And I frankly think we should have a discussion without it makes. It might make sense. So I can't remember the language. I wish I was here.
Something like if or how, I don't know. You see, might be able to fill in on that. But they do have experts at NRC, so I'm sure they're pretty big able to, but that was, I think you could say that.
We should look at the one just passed. And,
Yeah.
Cause and see if it's could or less what was implied.
But I think part of the question was it your memory that was something that was discussed in twenty?
I actually don't remember that, you know.
My conversation with Chair Sheldon is so that she remembers that being part of it.
It makes,
Yeah,
that makes sense. So,
yeah, and I think it did keep
I get the logic.
Changes. So, but in order to do that, I think those dates need to move out so that work can happen, because we're making those take a while. I believe the land use review board is not planning to do rulemaking on tier 2, they're just gonna provide guidance, and this would require rulemaking. And on the study of municipal land use decisions, or the appeals, municipal appeals, glad to see that is included. I wonder if the land use review board is the best place to house that. I think this is a important conversation about not just how to reactively respond to appeals, but how to proactively lessen the appeals. And that might be, having them in the group could be important, but that the leadership of that group may be better suited to another, could be bathtub. And I know Westfield Homes is actively already working on some of this, so having them as part of this group, I think, would also be helpful to ensure that work that they're doing is being brought into this conversation, but having it, I don't get to want great work for BAFTA either, but I think they may be. There may be better homes to move that conversation to ensure that it's not just about who is reviewing appeals, but what are all of the different ideas and we produce. Abuse. And they appreciate the guidance on how are things going. That's in there. I think that is incredibly important. We are hearing some challenging things from communities about how things are going on the ground right now. It's the first time that things seem getting worse when they're trying to do just really transformative work. So I'm gonna leave it there unless there's more questions for me.
All right, thanks so much.
Thank you.
Thank you. All right, we'll need to. Welcome.
Good morning, everyone.
Hi.
Thanks so much for having me in. For the record, my name is Lauren Pearl, and I'm the Executive Director of the Vermont Natural Resources Council. And I know you've been hearing regularly from a number of the VNRC team members, and happy to provide some initial reactions to the new draft of S325. Of course, it's only been out for a few hours, so we'll definitely put a lot more thought in and back with more detailed input. Just in response to Senator Hardy's question, just from VNRC's perspective, we've been really, as you know, I've been deeply involved with Act 181 for many years, all the stakeholder processes, and have been trying to really listen and understand what are the various issues that are coming up as this, monumental land use change is being rolled out and implemented, and trying to understand really first and foremost, are there issues where, and kind of tying into S325, where potentially we might want more time so we can get it right, or there's some time sensitive clarity that can be put in to make sure that it's working as intended. And it was like so many years of effort. So we've been trying to just be helpful. Like there's things that are I would say, other people's priorities that we're just trying to say, okay, here's like a way you could do it that we could live with, but I wouldn't say that this is something, so we're trying to kind of be team players. There's a lot of chatter and it's been a lot of requests from a lot of legislators. It's not like stakeholders are like, must do this. It's more, a lot of legislators have been asking us, some of your colleagues, some colleagues in the House. So it's really trying to be responsive to those requests of trying to get some thoughts, not like drafted legislative language, but just hopefully it can be a resource as people are thinking through, how do we make this huge change to our land use laws actually work in practice as we roll it out. And, so really just fundamentally, we're still kind of coming in with this premise of believing that Act 181 is setting up a great framework where we can have abundant affordable housing, working farms and forests, a healthy environment and resilient communities. And so we're kind of looking at the range of ideas that are coming out this year, again, with this, are there areas where more time let us do the work better and more thoughtfully and get it right? And are there areas where clarity in the short term can help us successfully implement the law? So, we're going to be proposing amendments that fall outside of that scope if people are trying to change the fundamental balance or underlying premise. I really like the way the legislative intent is laid out and kind of aligns with how we're thinking of it as well. And, really, as we're in the midst of this process, trying to do clarity and take time to do it right makes a lot of sense to me. Continuing to tinker with and change underlying policy is just going to delay, add confusion. It's going to mean that all of this takes more time. And I know that we want certainty and we want to get things going. I think as we get back, the kind of full scope of work is all this mapping, all the rules and regulations are developed. Then we'll have a much better sense. Okay, we can look at it comprehensively and say, what's working? Is this working in all parts of Vermont? Are can we assess, like, are there more substantive changes that might make sense now that we see, how did this actually play out on the ground, for planning all across the state. So that's, I think, going to be an important next phase of this, but I don't think that's where we are in this moment. The proposals in S325, I think, generally do make sense to us in that vein of timelines and clarifications. So extending the timelines for tier 3 and the road rule. I do think more time, given how it's playing out, more time for education, listening, outreach, really listening and shaping the rule thoughtfully. I think the conversation that Megan was referencing about looking at the criteria and things like that, I'm certainly open to that conversation. That was our understanding of the law as enacted, was that you could potentially consider looking at which criteria makes sense, in the vein of that tier is supposed to be protecting critical natural resources, that's what we want to do. So if we can do that in really thoughtful way, then great, that's the goal of it. So do support extending the timelines for those. We've also supported a potential extension for criterion 8C rulemaking, which is not reflected in here, something people could consider. So that is the fourth ratification criterion. That was also included in next meeting one. No, is it in there?
I think it is.
That was the piece that's not, certainly the language is laid out, but the
Gotcha.
it's
That's great. Good.
Yeah.
Then great. Great to have it in there. Missed that and I could read. So for extending the interim exemptions, I think, especially given the conversation today, definitely interested in looking at, how can that be shaped? I think our goal has always been, we're going to be transitioning to this like permanent new structures and these permanent areas where Act 250 will no longer apply. So syncing up the timelines of the process so that we have, in the short term, acknowledging we have this housing crisis and trying to jumpstart things, but the point is to transition to the long-term permanent, areas of exemption, and then, the tier 3 and all of that. So I think making sure that we're lining that all up and that times are going to work is the meeting our goal. And so, if that, I think we've been open to that, we might need more time than we initially thought, but I think Senator Hardy's points were great. This is just keeping ticking, but try to get it right. Get that right. So we'll look at that more closely. Have you think about that more. We support the amendment related to the administration of Act 250 permits in tier 1A areas. I think, it's just this gap and it can just kind of make the program work, so that seems reasonable. We will have some input on the tier 1A area guidelines that are required. But again, just a little more time to think about that. We can come back to you with some thoughts there. We support the inclusion of the appeals report. This is really more focused on municipal appeals. So the first report that came out was really looking primarily at Act 250 appeals. So to us, this is like a logical next phase of looking at the different set of issues and concerns that are coming up. And certainly, interested to keep thinking about who's the right entity to conduct, help convene that report and stakeholders are, I think, some good ideas were suggested over that conversation. But I think doing that report will be valuable and hopefully it could be something that could be actionable with the timeline and process could be set for action next year at the legislature on the recommendations. One issue not included here that you might consider adding is allowing municipalities to apply for tier 1B designation at any time, independent of regional plan approval processes. This is something we've been hearing as towns are not opting into tier 1B as much as people thought, that if they have to wait, if they miss this round and have to wait for the next approval process, there might be some towns that get their ducks in a row for a couple of years and could be that could be another time and way to do that. So we would support that. And
So just ask a question about that.
Yeah, good.
So as it is right now, it's every 10 years they do them in the regional plans and can opt into 1B.
If you
Kate Gallagher with Vermont Natural Resources Council, my understanding is they wouldn't necessarily have to wait until the next full update, but the RPCs are concerned that they would still have to go through many of the steps of a regular regional plan update, getting approved by builder prior to the full update.
Okay,
So it would just be a lot of time and resources on the regional planning commissions for it, seems unnecessary.
I see, okay.
So the idea would be that there be one eligible and then the town can opt in, whatever the right opt in, then it's going to sense.
yes, yeah. So those are the initial thoughts. Really appreciate the time and effort you all are putting into this. Appreciate your consideration.
Super. Thank you so much. Any other questions at this point?
Just say about the simplest level. Giving the board more time to do its work and then bringing the extensions to the same distance. And which I think is a big extension sign. So it's kind of myself logical.
Yeah.
Just a matter of giving 4 or 5 extensions. Very within the work.
Yep. Very good.
So, and getting it right is work. I mean, one thing as we get older, we realize is that a year comes and a year comes. So.
Okay, super. Well, thank you so much.
Thank you so much.
All right. So more to come on that topic. We're going to switch topics. Now we're going to switch over to S-138 on commercial pace. We're joined this morning by Mr. Delia. Welcome.
For the record, Chris Delia, President, Vermont Bankers Association. Madam Chair, how would you like to proceed? Because I listened to your hearing last week. You folks had a lot of questions. I can try and answer some of those questions. Or just give you my opinion on the bill and then let you pepper me with some.
Well, I think we should go in that order. Let's start with your thoughts on the bill and then we can move to questions.
So, my background goes all the way to when we did residential pace. I was here in the building when we did that and worked with the folks over at DFR. I think you know the history of residential pace, but I have to shed some more light on that if you have questions. In this particular bill, in this particular draft, which I'm looking at 3.1, which you went through last week. The language that for us is most critical and is in there is found on page 6, lines 2 through 7. And that's where the entity wishing to take out an assessment or apply for an assessment has to go to an existing lien holder, mortgage holder to seek their approval to obtain such an assessment. That's critical because the commercial lender, as with residential as well, we need a priority position in front of other lien holders aside from property taxes, which is a given in Vermont, whether it's for commercial property, residential property. So to have somebody who's got a lien on a property, all of a sudden go and get another loan that sits in front of ours, and in the case of commercial, we could be talking a large sum of money, unlike the residential, which, you know, typically was 10 to 20,000. Here you could be talking, depending on the project, several $100,000. And that does not work for your commercial lenders in Vermont. So this language that you've got here is absolutely vital. It gives the property owner, the commercial entity, an opportunity to have a conversation with their lender. The lender may look at all of the circumstances of what they want to do and make the loan available to them without having to go through PACE. There may be such a small de minimis amount left on the loan that the lender says, sure, have at it. I think the other thing that's important here is by giving us this consent, we're also helping to preserve the position of the Vermont Economic Development Authority, which often we partner with on commercial loans. They sit in second position behind the bank. And without this consent, theoretically, they go to third position. And they think they would want to do that. So this language is critical, and we appreciate seeing it in the bill.
Absolutely. Wondering if you can speak to, I don't know if you are familiar with PACE in other states. PACE in other states, and if that is common, we can ask other people this question as well, but
If the language is common,
this kind of provision is
Yes.
common in other states, commercial PACE.
I have not looked at all 38 states, but the overwhelming majority have this consent language in it, including our neighbors in New Hampshire, which works well because a number of our banks serve New Hampshire as well, so there's a commonality in the market. This type of program.
Great. Super. Any other questions? Yes, go ahead.
Hey, Chris,
Hi.
so I just fundamentally don't quite understand this program. You might maybe lift into my just overall confusion, like why?
Yep.
Why would somebody use this program and why would a municipality do it?
Sure.
And isn't it and with all the things of the, you know, you can contract with another entity to
Yep.
administer it and everything, why wouldn't somebody just go to a commercial lender?
Right. So the concept behind PACE is critical to have the municipal involvement because they're the only ones that have the lien authority is contemplated in the bill. In other words, it's gonna run with the property. You're making a loan not to the property, you're making a loan to the entity that owns the property. So if that is the mechanism that the legislature wishes to use as repayment, we've got to have a municipality involved in that way. In hearing your comments, what ultimately happened in the residential PACE was municipalities did not have a capacity to initiate a PACE program. So for residential, they went with Efficiency Vermont. They handled all of the mechanics behind the scenes. And basically the municipality just created the district and they utilize their lien authority to establish a lien on the property. But the municipalities didn't want the risks of taking out property. You don't get repaid, the property tax payers in that community, you're still on the hook for that money, so that goes away. What you've got here is the concept of contracting with a third party, which is important. Because again, I don't think you're gonna have many municipalities that have the capacity to do it. But you do need a municipality to create that mechanism for repayment when you're attaching to the property.
Okay,
Could you go to a commercial lender today? Yes. But you have to understand that a commercial lender is gonna look at all of the circumstances of the borrower and all of the underwriting criteria that they have at their disposal to make a determination whether that borrower, whether the credit risk with that borrower is low enough to warrant making the loan and that repayment will occur.
right,
That can happen today, but I will assure you that there will be some projects that don't pencil out.
right, but so then if that happens, they go to a bank.
Yep.
And try to get a loan and the bank says no, and then they try to do PACE.
Yep.
Because the lien goes with the property, that the risk is worth it because there's a lien on the property.
Well, you're changing. Theoretically, you're changing the terms of the loan as far as repayment of those funds. Which is going to be for a longer period of time than you're going to find on typical commercial loans, 7, 10, 15 years. So when you can go out beyond that, the repayment amount is less on an annual basis. And I don't know what, aside from the testimony of that national group, I don't know what they might be able to obtain from an interest rate, which may or may not be a little bit lower than what the typical market is, so maybe that helps as well. But ultimately, at the end of the day, is if a commercial lender is looking at it, we're looking at all of those circumstances and underwriting to say, are you a good credit risk?
Yeah,
This just gives a little more flexibility on the repayment terms.
and do you know, I mean, maybe we should have that efficiency Vermont in, but do you know how did it work well for the residential program?
Well, in my opinion, it didn't work well for a couple of reasons. One, in looking at the issue of energy efficiency improvements in your home, to me, the best model that was out there at the time that I looked at it was NeighborWorks down in Rutland. Because they, if you will, held your hand through the whole process.
Yeah,
They said, here's an opportunity for you. Here are the contractors, here are the steps you're gonna have to go through. We don't hear anything within a few weeks, they're on the phone calling you up, hey, how's it going? You need that,
a community-based in-person navigator.
good point.
Yeah.
You need that to stimulate somebody to move in that direction,
Yeah.
because you have people who aren't thinking about it, don't have the capacity to think about it, have the money but don't care, whatever it may be. That was the best model out there. Absent that, you had communities who adopted this, and without that handholding, nobody worked it. You also had the complexity, again, in my opinion, developed by the Department of Financial Regulation, that was more akin to traditional underwriting standards that you would find in the marketplace. Whether it's efficiency, Vermont, or municipalities, you have to have sound underwriting standards to ensure that we are not putting Ruth Hardy in the water with the loan that she's getting on the
Yeah.
property. And all of that changed because residential base was pre the financial crisis. All of that changed during the financial crisis because now the highest criteria that we're required to look at is ability to repay. You don't have an ability to repay, we're probably not doing that wrong on mortgages. So
Yeah. Commercial side. Yeah, so. I guess. I'm concerned that if. I don't know, I can't wrap my head around this one, like if. I'm not sure why the municipality would take the risk of having a lien on a property. Well, I mean, could this potentially harm a municipality if they? Participate in it?
If it's structured with a third party. And that third party is funding the loan. And the obligation to repay. Is. Let me rephrase it, if the losses are going to be absorbed by that third party. Then I think there's less risk to the municipality. If the municipality were creating a loan pool and lending out the money. And there were losses, the municipality is going to be obligated to repay those funds to wherever they got the money from.
Yeah,
That's where I think the real risk is to the municipality. But a municipality theoretically under this bill, if I'm reading it correctly, could go to the voters and say, we want this block in our town to be a district. And we are going to contract with whoever decides to step up and be the party to work with the municipality. And that entity is going to assume all of the obligations to run the program, risk of the program. At that point, the municipality is only providing their property tax lien mechanism to get the funds repaid.
okay,
At least that's how I'm reading
okay,
the bill as you've got it.
yeah, I mean, originally, I think it was the other way, that the
Yeah.
municipality took the risk, and it's like, why would?
I don't agree that I could probably count on one hand, the municipalities that might want to do that under the old scenario.
Yeah,
I think you've lessened that concern here in this bill.
okay,
That said, municipalities should know what they're getting.
yeah, and a lot of our municipalities are not that sophisticated, they just don't have the staff to deal with it, or.
Staff resources,
Yeah.
work, so we hear
Thank you.
it.
Any other questions? Okay, super. All right, thank you so much.
Thank you.
Yeah, for sure. Okay, so we're gonna go to Mr. Pullum, who is joining us virtually, I believe from Connecticut. Mr. Pullum is the managing director, the head of PACE Ratings and Analytics at Counterpoint Sustainable Real Estate. Can you hear us? Seems like maybe the answer is no. No,
Sorry,
Michelle?
I was on mute. Yes, I can hear you, and there I am.
Super. Well, thank you for joining us.
Thank you for having me.
Would love to hear any thoughts that you have about, in general, how PACE works in Connecticut, and I mean, I'm sure I have questions about how it works, but would love to give you the floor.
Great, thank you. Kurt Pullum at Counterpoint Sustainable Real Estate. Counterpoint is one of the oldest providers of C-PACE capital in the nation, going back to 2014. I was at Counterpoint in 2016 to 18. Took a detour, came back here 2 years ago. So I've been involved with PACE for a very long time. We are not just a capital provider, we are a PACE administrator in California, Florida, and Chicago. So we have experience also on the administration and servicing side. We are backed by MassMutual, so we actually invest really solely right now for MassMutual as a life insurance company and originating PACE investments for them. We are just C-PACE, though originally our founder, Eric Alini, was involved with our PACE and the tax lien business in Florida. And I was listening to Chris's comments. I did watch last week's meeting just to understand where you are with the bill and what your concerns were. And, you know, they're important ones to consider. I will say the one issue on the municipality and their involvement, you know, largely we have 40 states, right? So we have, at this point, PACE is a pretty mature financing vehicle for energy and resiliency improvements across the United States. And typically, municipalities these days don't have really any involvement other than their involvement with creating the tax lien that goes on the tax rolls. And there are two ways to collect the assessment payments. Really, you can do it as you do the real estate taxes, which is it's on your tax bill. You pay it to the municipality, and then they pass the assessment payment to the investor. And then there's in the minority of states right now, there's a direct billing that happens where really they're not involved at all. Even with collecting the assessment, it's direct payment to the investor. And so the involvement really with the municipality is just opting in. So if you pass a legislation, the city doesn't opt in, where they do an opt-in agreement, an ordinance, passing PACE in their district. And then the program administrator would handle really the rest. And I'm saying that from experience, as we're actually one of the first administrators in Florida and California, which were pioneers in PACE. California was the birthplace of PACE. And so I think that is something that largely I don't think would be a concern here with passing the legislation. And the other issue that I heard, which is understandable, is why don't banks do this, right? And getting back to what PACE does, which is it's helping to fund these energy and resiliency improvements. It's meant to roughly tied to the duration of those investments, right? So you are funding a long-term investment, and the PACE itself is a long duration asset that's created. And so banks don't generally, I mean, they can do 20, 30-year long type loans, and but the PACE is an exception that way. So that also factors into the pricing. I know that's probably an issue. PACE can be a lower rate, but that's also balanced with the fact the long duration asset. So you are going further out just on the pricing mechanics. But if you're a long duration asset, you're tying that to, say, the 30-year, the 20-year treasury. So that impacts what the rate might be. Similar to a mortgage. But the other important issue is that what you've talked about, which is the PACE doesn't accelerate, right? So it's tied to the owner of really the tax parcel. It's tied to the tax parcel. So if that owner decides to sell, the PACE, the assessment stays with the property. They can pay it off. They don't have to. And if there's a foreclosure, if there's a non-payment, that's handled just like non-payment of taxes. So it doesn't the whole assessment doesn't accelerate. You're just owing back assessment, and as you would with the property taxes, and you're doing this with the existing mechanisms that are in place for unpaid taxes within the state. I'm going to stop there and see if there are questions.
Yeah, sure, go ahead.
Thank you. This is helpful. Two questions. One, does your company charge the municipality anything to manage the program?
It's actually the other way around.
Okay.
Yeah. So, if the municipality is involved, it depends on, each state is different. That typically, if we'll take Florida as an example, maybe not the best example, but the fees are an issue. They charge to collect assessment payment and pass it along to us.
Okay.
And
So
I will say those fees are paid by the property owner as part of the assessment.
Okay, I don't know if you've ever been to Vermont, but our towns are tiny. And I'm very concerned about putting them at risk if they end up doing this, so, or costing them any money.
Right.
And if you've been doing this for a long time, do you have any data on the sort of, the default rates on these loans? Or is that not a thing because it's tied to the lien?
Oh, no, it's a thing. And we can get into, all the credit aspects of this. I'm gonna back up though and tell you, I am a Vermont resident, Manchester Center. Yeah, so.
Awesome.
Yes.
You have been to Vermont then.
I'm yes. Well, obviously, these days I'm in Connecticut during the week, but on the weekends, I'm in Vermont where my daughter is there permanently, going to school there. But yeah, so you get into sort of the credit aspects of how we look at PACE, and I know this is one thing that came up in the bill, which is what are the limits on PACE? I know you have in there that it's an all-in LTV of 90%, and that's fine. I see that's pretty common type limit. But when you look at PACE and where it sits, generally, and I can tell you our own underwriting criteria, but that of our competitors too, is we're not more than, say, 30% of the property's value. And because I'm doing commercial PACE, that's income producing value of that piece of real estate. So we really look at the ability of not just the current property owner, but future property owners and what that property is to be able to paying the assessment payment, in addition, of course, the taxes and other operating expenses, and a mortgage if they have a mortgage. And that gets back to lender consent, which I can tell you is standard. Lender consent is you need to have that. It's kind of, Chris reiterated that, but it's very common and necessary because PACE is going to be senior priority to the mortgage, typically pari passu with the real estate taxes. And so we generally, I mean, I can tell you our defaults, which is, we service 9,000 assessments all in. We have a rather large book approaching $1 billion. And I think we've had like one or two that were a problem. So that goes back to our rigor as, how we invest. We are investing, like I said, for a life company. So we're pretty strict in how we underwrite PACE within the relationship of not just the property, but also the rest of the capital stack with the mortgage lender. I can tell you that, mortgage lenders involved, which they mostly are, they're the ones that decide how much leverage is on an asset and what they're comfortable with and where PACE fits with that.
Okay, thank you.
Great. Yes, go ahead. We have another question.
Kind of protections are available safeguards for the people being involved?
What are the safeguards?
Yeah,
On the commercial side or?
no, first on the residential.
Well, I see. So we're not experts at residential. We haven't been involved with residential PACE since, before 2016. That has absolutely been an issue. I mean, the problem that happened in California and Florida was there was widespread abuse, right? And California enacted consumer protection laws just for that reason. It was people were taking advantage of homeowners who didn't realize what they were signing, right? They were like, oh, I'm getting this great solar installation. They didn't understand that their property tax bill was going up by 2, 3, 4-fold, right? And so consumer protection laws in residential PACE, I think are important to prevent that from happening again. We don't see that. It's not really a consideration in commercial PACE. We're dealing with institutional capital for the most part not for the most part. all the money coming in at CPACE from CPACE is institutional capital that is, in our case, we're actually regulated by the SEC. We're an RIA, so you're not going to see any abuse from us on the commercial side. And we can talk about. I know there was question of, well, and I understand why PACE is important for the smaller homeowners and business owners in Vermont. We do PACE as low as, well, sub-million, and we'll do that for small apartment complex owners. We'll do it for small businesses that are putting solar or other improvements into their property, because it's an important alternative source of capital for them. The upfront cost, because we'll finance up to 100% of the solar or the HVAC or the heat pumps. The fact that you can amortize that over 30 or the useful life, right? And effectively spread that cost over the useful life of the improvement that you're putting on the property is very useful. And I think there was also the question on, well, how do the payments work? It's really simple. It's a level pay, amortizing fixed P&I payment. It's a schedule that's set and put into the assessment contract and the financing agreement that are signed and memorialize the assessment that's being put on the tax rolls. And so PACE is also very passive. So we don't have, short of like a default, we just sit back and collect the payments and don't have any involvement.
Good, thank you.
And this is just about commercial base.
Right.
Yeah. Okay. Any other questions? So I would actually love to hear a little bit more about how, because you it sounds like you're working in a variety of states. And maybe this question has basically been answered, but I just want to revisit it about how this works for very small municipalities that don't have a lot of capacity. If you're here at least some of the time, that like some of our towns, they may only have a town clerk. They may not have any other staff.
Right.
So can you speak to, and maybe it's just this direct billing is how that is managed, or are there other considerations that we should be thinking about for very small municipalities?
Yeah, no, sure, understood. Well, yeah, so we're national. There's no state or program we don't deal with and invest in. And it's interesting, there's a number of ways you can do an opt-in on the county level or the city level, town level. And so like if your entire county opts in, then it certainly makes it easier on, as you said, it's like
That's not how things work in Vermont.
Yeah, unfortunately, our county level systems are more or less non-existent.
Right.
It's either the state or it's municipal at this point, unfortunately.
Right. It still wouldn't be like you have a standard sort of tri-party agreement between the municipality, the program administrator, and the capital provider. And there are states that have very standard opt-in agreement that you take to your town, to your city council or your town clerk, right? And they all vote on it. And that's the other thing. It doesn't involve any sort of widespread vote by your voters. It's because this isn't a one-off. Each property owner decides whether or not they want to utilize PACE to do their energy efficiency projects. And so once the county opts in and the agreement is in place, and they've agreed, that they're going to put the assessment on the tax roll and to whatever the collection mechanism and agreement is, then it's like, there's very little to any involvement on on the town level.
Yes, we have another question here.
So. Banks like to get paid monthly, but municipalities in Vermont collect property taxes usually twice a year.
Yes,
What happens then?
that's how it works.
Okay.
We get, investors are paid at the same time as, well, not the same time. There's usually a grace period and call it a month between when the assessment payment is due and the investor payment from the assessment. So yeah, it coincides with whenever those are collected, and that's how we deal. You know, in California, it's twice a year. In some states, it's once a year, and that's, yeah. There's no, we're not like a mortgage where it's monthly.
And
Yes, go ahead.
this bill does require the voters to vote on whether or not to have a district. So it would be a vote of the entire town on whether to opt in to having a district, is my understanding.
Yep.
Yeah.
That's going to be a barrier then. So that's not something we see. I mean, I could see it maybe with our pace, but with C-PACE, we don't, that's not standard.
Yeah, and that language was left over from our original draft, so that's something that I think that's worth talking with, but
Can I ask?
yes, go ahead.
Chris, actually, I think it's more for you. Do you have the draft in front of you? The bottom of page 10, top of page 11. This is about the lien. It says that the lien shall not be subordinate to all other liens on the property in existence at the time the lien for the assessment is filed on the land records. So does that mean the PACE lien is the priority lien?
Who's being asked that?
I'm asking Chris Celia, who's in the room, but I
So it
mean,
would not support it, so it would be in a priority position.
so the PACE lien would be the priority lien.
Correct.
So any other liens on the property would come second or third or whatever. Is that? Do you think
Well, that's why
gonna
the
be an issue?
consent language is important on page 6.
The language that you mentioned.
Yeah.
That's. So that the.
It's like-
The bank the mortgage would still be first and then Vita maybe second and then the PACE loan would be
You
third.
may come to us with a request. And we're gonna have a conversation and we're gonna understand your overall circumstances around your borrowing with us. And we're gonna say, Ruth, we're not gonna consent to a PACE loan. It's too risky to our position as a lender.
Yeah,
We may say, Ruth, you only owe 10 grand. It's a de minimis amount and we don't see where a PACE loan would be an obstacle. So we're gonna consent to let you take that PACE loan out. That PACE loan with that language that you've referred to on page 9 and 10 takes a priority position in front of our de minimis amount of $10,000.
oh, so after you consent,
Right,
you consent to being the lower,
correct.
and
And that's why it's important for those conversations to happen. Because if our skin in the game is a few $100,000 or $1 million. Chances of us consenting and running the risk of not getting paid is probably not gonna happen.
yeah,
Without the consent language. If this was just to go straight through without any communication to the bank. The responses that I've gotten is commercial lending in those communities with C-PACE program will not happen.
yeah,
Just won't happen.
Yeah.
Risk are too high.
cause exactly. Okay. All right, thank you. That's.
Great, yes, go ahead.
So remind me why the PACE loan has to have top priority. So we're doing.
Well, because structurally, that's your policy, the way you're creating it in this bill. Is it's given that priority because you're treating it just like property taxes, no different than property taxes.
That's okay.
If you could have a policy that does something different. That puts it behind a commercial loan. In that case, you wouldn't need lender consent. Because it's taking less of a priority compared to the commercial loan or VDEB. So
And what would happen to the program viability if we did that rather than,
I don't think you're gonna have much success.
okay?
Okay. All right, any other questions for either Mr. Pullum or Mr. Daly? Okay, great, thank you so much. Thank you for joining us, really appreciate your testimony.
Thank you. Appreciate it.
Yeah, okay, and so at this point, I know we are scheduled to go into a new topic, which is S224. But I do want to take a quick break. Let's take 5 minutes.
Hey, Kevin? Kevin?
Yes, hi, good morning.
Hi, Kevin. How are you on time?
Well, 11 o'clock, we have a scheduled interview. That's why I'm kind of
Yeah,
tight.
okay, well, hopefully we'll be done with that because we've got Mike O'Grady coming in at 10:45, but they needed a little stretch break. So she told them 5 minutes, but it's been 5 minutes, so any moment we should start.
Sounds good. I'm here.
Okay, thank you. Hey, one other question, Kevin.
Yes,
Did you see the latest draft that I posted this morning?
that would be 2.1.
Yes.
Yes,
Okay.
thank you.
No, Kevin? I'm about,
Yes,
a draft that says 4.2.
I did not see 4.2. I'll have to look for that one.
Okay, sorry.
That's okay.
We're live.
Very well. Yes. Okay, let's do that. All right, this is Senate Natural Resources and Energy coming back from break, and we are joined remotely by Mr. Burke from A&R from yes, DEC. Welcome. Excuse me.
Hi, Chair Watson. Hi, committee members. It's nice to be here. The last time I think I joined your committee, I was working in the stormwater program here at DEC. I've recently taken a position after the retirement of our former director, Pete Laflamme. So I'm now serving as director over the Watershed Management Division.
Great, welcome. And one of the things that in relation to S224, we know that there is a draft rule that is has a lot of similar topics to things that are in S224. I'm wondering if you can share with us about that.
Yeah, the current rule essentially covers municipal delegation. It covers wake sports. It covers, it's basically a reissuance of our rules, taking into account some of the necessary changes to deal with some of the emerging issues, So we think that's really the best place to have a lot of this language that's included in the proposed bill. I didn't know if there was anything specific within those rules that you were most interested in.
Sure, well, there's a part about municipal delegation, and there's a portion about wake boats, so, but if we could talk about, because there's a part that that is currently in S 224 that I think is gonna be coming out, but if you could speak to the municipal delegation aspect.
Yeah, I think I would say that the municipal delegation in the use of public water rules is sort of better suited to deal with designating a municipality. It also involves, through the rulemaking process, it also involves a fair number of stakeholders and public comment. I think it's also worth pointing out that, despite municipal delegation, it would not, whether it's in this statute or in the rule, it doesn't give a municipality the authority to make their own rules. And even if it did, the public water rules would not include the ability to regulate fishing. It's really only specific to the types, sizes, speeds of boats. So that authority with regards to fishing really remains with Fish and Wildlife. Our rule also, I think, provides a little bit better clarity on some of the roles and responsibilities for a municipality that's seeking delegation. So I think that's one of the other important aspects in the differences.
Yep, that's fair. And then can you speak to the aspect that has to do with the changes relative to wake boat available areas?
Yeah, I think one distinction to make from this bill and the rules, one thing that I think needs to be clarified if this bill was going to include anything on wake boats, is that the prohibition or essentially wake boats are allowed in certain designated zones, but it's not necessarily a prohibition of wake boats as a whole. It's really when these boats are operating in what's called wake sports mode. So there's really the bill is in conflict with sort of how the rule speaks to wake boats. So I think that's just an important clarifier, because these boats can operate in non-wake sports mode and they wouldn't otherwise be restricted on really any lake. So as long as, the lake is permitted for combustion motors.
That's interesting to think about wake boats being allowed, but not in their wake mode, that effectively they become a
just a motorboat.
Motorboat.
Yep. Yeah, because the wake boat mode, the wake sports mode is a specific mode that then, they use the ballast tanks to create larger wakes.
Right. Did you have a question?
Well, so are we talking about the proposed rules?
The proposed rules do make the distinguish wake boat from wake sports mode. So it's really specific to wake boats operating in wake sports mode, as opposed to simply prohibiting wake boats or only allowing wake boats to operate in certain areas. It's really only when they're in that mode.
Yeah.
Okay, and is there such a thing, but how would we actually regulate that and make sure that water isn't passing through the ballast? Like under, I guess theoretically it doesn't if you're not in wake sport mode, but it sounds awfully tenuous to me if we're really worried about contaminating water.
Yeah, I think we're talking about maybe two different things. There's restriction on where wake boats can operate because of the larger wake that they create in that mode, which would be, looking to have them operate in areas where there's plenty of room from the shoreline. There's adequate depth because they do generate a fair amount of wake. And then there's the aquatic invasive species piece of it where, if a wake boat is moving between lakes, there is the need to decontaminate. And, there's a number of provisions in this bill that speaks to the home lake rule and puts that back into place. We've gone away from that simply because boats are both coming from out of state and in state. So not necessarily addressing that through DMV would get at, identifying all of the wake boats that might be operating in Vermont. But really just making the requirement that any boat that is moving between waters is properly decontaminated. Just like any other boat that would be traveling between waters, but the difference being that wake boats would require a hot water decontamination.
So are we talking, when you say that, so what's contemplated in the bill, I think, is that a wake boat would have the home lake, couldn't move without being decontaminated, and a boat could not come in from out of state without having been decontaminated.
Right. There's just a real difficulty in tracking to know what wake boat has been decontaminated without, there's no sticker. We couldn't necessarily know of all the wake boats through a DMV registration. And greeters, for example, that are often at some of these access areas wouldn't have access to any sort of database that's tracking those boats. So it really, it becomes a little bit problematic in terms of how we would track and implement the home lake rule as it is written in the bill, which is why we aim to clarify in the rules that simply requiring a decontamination and having some proof of that if you're moving between lakes.
Okay, so that rule is one we share, I guess, so the question is whether we statute or whether wait for that. Is that in the proposed rule?
The requirement for decontamination?
And proof thereof?
Yes, we haven't developed what that proof would look like, but it would be some, it would be something that they could provide to a greeter or maintain to prove that they have decontaminated. We also have a report that identifies, some of the expanded boat wash and decontamination stations going forward, and also identifying the ones that exist now for a hot decontamination wash. So there would be a process for ensuring that if a boat was decontaminated, they would have proof or a receipt from that activity.
But you are saying that you are dropping the home lake, any kind of a home lake rule?
Yeah, the home lake rule is not part of the current rules before ICAR.
Okay.
One of the possibilities that we're gonna see a new draft soon, but something we've talked about is the possibility of having wake boats be identified at the time that they're registered, that the DMV could alter their registration form to include a box to say, like, is this a wake boat? And do you have a home lake? I'm making an assumption, but I'd like to check it with you, that would be useful information for you to have.
It certainly could be useful in terms of identifying boats that are wake boats that are registered in Vermont, but we also have a lot of shoreline property owners that bring boats from out of state and register those boats out of state, so it wouldn't capture that.
Sure, but it would capture the ones that are registered in Vermont.
Sure, it definitely would.
Yeah. Okay. Any other questions? Well, just to get at it, the rules around wake boat decontamination, your sense is your preference would be that be in rule and not in statute?
That would be our preference.
Okay. Okay. Well, thank you very much. Thanks.
You're welcome.
All right.
If you do have any follow-up questions, certainly can provide answers as necessary.
Okay, sounds great, thank you.
All right, thank you, everyone.
Okay, all right, and actually, before we move to Mr. Gray, I'd like to take a 1 minute break. That's okay, because it's your turn. Yeah, if we can take just 1 minute, that would be great. Can we? Okay.
Well, I was tracking down. My mother's, my 97-year-old.
We're online. Okay, thank you for that super short break. So we have a new draft of 224, and again, not totally done, but wanted to just give a little framework for what we're gonna see. So we did hear a lot of feedback about section 1, about the municipal delegation, but we just heard from Mr. Burke that they have their own section going through rulemaking. And that as it was, it would not have, we would have had to further amend it to give the municipality the ability to regulate fishing anyway. And so it made sense to me to remove that section, especially if we were going to be addressing that in a different way in section 8. So or what was section 8. So that is one change that you'll see here, again, responding to testimony and feedback. And then the other major change here is about the how we deal with the locations of boat washing stations and decontamination stations. And so this language did come from the Department of Fish and Wildlife. And again, this doesn't have to be where we land, but wanted to at least get this in front of the committee. And they also have some recommended language about the fishing tournament, which is not here. And we can talk about that separately, but I thought I would, we'd at least start here. So Mr. Grady, welcome.
Good morning, this is White Brigade, but City Council, do you want me to just walk through changes?
Yes.
So you should have draft number 4.2 with the February 11th date and a 7:40 a.m. timestamp. And
Yep.
The yellow highlighting throughout recognizes changes that were made between this draft and the previous draft reviewed by the committee. First change, as the chair just referenced, the previous section 1 on municipal delegation of authority over the use of the water has been removed. It's no longer in the bill. The second change relates on page 1, line 7 in the reader assistance. You will see later on that there's a section regarding motorboat registration. And so that term was added to the reader assistance. So moving on from there, the next change is on page 2, going on to page 3 in the section that was in the previous draft related to use of waters by wake boats. So on page 3, lines 3 through 7, in order to operate a wake boat in Vermont, the person who owns or controls the wake boat shall, on the vessel registration or validation form, annually or biannually identify a home length of the wake boat for the calendar years for which the registration or validation is valid. Okay, so this is the registration form. You can see that vessel type is already something that they ask for identification of, and it includes things like houseboats, open motorboats, pontoon boats. The DMV said that it'd be easy well, they'd be willing to add wakeboat to this form. Now, they do register, as with your car, more than annually. You can register biannually, so that's why it says biannually. In addition, there's something called a validation. It's when you are an out-of-state vessel and you come into Vermont and you're gonna be in Vermont for more than 60 days, you have to fill out, basically, it's a temporary registration, but they call it a validation, so that they know who you are. There would be vessels that come in from out of state that do not need a registration or a validation if their state follows a comparable numbering system or federal numbering system. So yes, there would be wakeboats used in the state that would never have to get registration or a validation.
But if they're here for more than 60 days, they should be doing the same.
They should be getting validation. On page 3, line 14, where it had previously said existing boat watching stations shall not be considered an agency approved decontamination service. US said existing be removed. The question is, do you still want ANR to have the ability to approve a boat watching station as a decontamination service? There was proposals from some advocates to strike that in less phrase. But I never received that directive from you.
I am, where are you? I think I've lost where you.
Page 3,
Okay.
lines 15 and 16. Because it
Oh, wow.
previously said existing boat watching station.
So, okay, this is a little bit funny, but you have a page 3. I do not have a page 3. It goes 1, 2, and then 5. Isn't that odd?
Does anybody else have that problem?
That's, yeah, you have a page 3. Yeah, that one works. Okay, great. No worries. That's just very funny. Okay, why I couldn't find you. Sorry, so page 3.
3, line 14. Previous draft that said existing boat watching station. And then you had that conversation about existing prior to what? And then you had the conversation, well, it should just be any boat watching station shall not be considered decontamination. But then there were advocates who are saying that the agency shouldn't be allowed to approve a boat watching station as a decontamination service. I did not make that change because you did not directly make that change.
Thoughts from the committee on that? Or do you need it one more time?
Well, we need a one more comment. What we're trying to achieve there makes sense to me. It's a matter of how you're saying it.
I think the advocates want decontamination sites to be a totally separate thing from boat watching stations. And they don't want ANR to be able to turn a boat watching station into a decontamination service.
How to count as decontamination?
What chances? Right.
The boat.
So the cold water at the boat washing station doesn't count.
Right.
It's washing.
Yeah, it's not a good place to be contaminated.
Yeah. Oh, so that's.
So take care.
So the fear is that the need for the hot water will get.
Or just site constraints, will a decontamination service have more runoff because of the need for the type of treatment? I think that there's some just concern about they're not a one-to-one. And the advocates would prefer that a boat washing station be separate from decontamination.
That makes sense to me so the idea is to add more specificity on what that means, or to just not have it.
Or just straight
Right.
that phrase unless approved by the agency to provide decontamination service. So,
Okay, now I.
Yeah. I agree that like either we need to provide guidance about what a decontamination station consists of, or strike that language. It's. The thing is, like, could you watch a boat, so I guess it's like if you had a decontamination station, could you wash your boat at that location? Probably, but this is really going the other direction. And
I do think that there are probably some washing stations, inspection stations that currently could be a decontamination service or could be retrofitted or outfitted to be decontamination. But do you want the assumption to be that washing stations will become decontamination stations? But I think that's part of the
right.
anxiety about this.
For simplicity, I'm happy to strike it, the unless approved language, but thoughts from others.
I like this.
You like this language, like unless it's approved?
Yes, we have a really quandary that you've identified, I think, is that it may not make sense 80% of the time, 20% of the time, it might make sense to have a located. We're not excluding that. It should just make clear that decontamination station is separate.
You need hot water, you need drainage, so you need certain site, just to control runoff control and things like that.
Probably not gonna be a boat launch. Are we really just simply saying, I mean, could we really just say that decontamination, the section of decontamination station must be certified by say or something?
Or do we need a definition of decontamination?
That's what.
Yeah,
Is it just a definition and not even say or is there something?
mhm,
Okay.
Now, you said that they're designated agency for the greeters. Didn't want ANR to be allowed to turn their sites into decon stations, right? What are we talking about specifically? Because it sounds like you got a turf file.
But I received a draft of markup from advocates. Water quality advocates, lake advocates. And that's what they were looking to do, to not allow ANR to approve a washing station as a decontamination service.
For what their intended purpose or what they're doing in their rooms. So.
But if you added a definition of decontamination service to some of the criteria that you want, use of hot water, the ability of draining, and or control runoff with sufficient space for treatment. Then I think you could turn this language into boat washing stations shall not be used as a decontamination service unless it meets the criteria for the decontamination service and is approved by the secretary for that purpose.
I like that.
And does not interfere with use of the current boat market.
So who would be the agency, ANR or DEC?
ANR, I consider the boat washing and the decontamination to be part of the aquatic nuisance chapter, and that's authority that DEC has authority over.
Who would be the agency responsible for defining a decontamination station? Or
Well, it sounds like we would be doing this, yeah, so if, especially based on the criteria you just mentioned. Sure, that'll be, feels like at least a good place to start.
Right.
Yes,
Don't qualify to you.
I think we get input on
You are the supreme policymaker.
I know.
Underneath.
it.
Fish and wildlife biologists know what temperature you have to have, how much water, that we don't really know that.
Well, they can comment on that.
But remember, DEC still approves. DEC still approves of it meets the criteria.
Okay, thank you for that discussion.
You can skip to page 6. And sections 5 and section 6 relate to registering your motor boat as a vehicle. And so the first section that's being amended, page 6, line 3, is the definition sections underneath the chapter, subchapter in law related to vessel registration. And what is being added is on page 7, the definition of a wake boat. Motor boat that has one or more valves, tanks, ballast bags, and other devices or design features used to increase the size of the motor boats.
Let me go back real quick to page 6, line 5, unless the context clearly requires a different meaning. And it's just interesting that that's being struck.
So this is old language.
Okay.
Under our new drafting manual, we don't use that language, and when we come across it, we're supposed to cross it out. And even if I don't want to cross it out, because I think it's going to create a question, the editors will cross it out.
Okay.
So I don't get to avoid that one.
Okay,
I try. But
all right. Thank you. I figured it was something like that, but just wanted to confirm. Sorry, please carry on.
so you have that definition of wake boat that's consistent with the definition in both the use of waters for the statute. And you come to page 7, line 12, section 6. This is that section for vessel registration. You will first see page 7, line 18 is annually or biennially. And then on page, I also want to point out page 8, line 20 and 21, that the registration certificate is pocket size and shall be available at all times for inspection on the motor boat for which it's issued. So if wake boat is added to this form and you identify yourself as a wake boat, you're going to have a pocket size registration that you're supposed to have available with you all the time. So then moving on from there, bottom of page 9, line 19, this is the directive that application forms that the Commissioner of Motor Vehicles provides for registration of vessels shall include a checkbox for an owner to designate a motorboat as a wake boat. If the owner designates a motorboat a wake boat, the owner shall designate the home lake of a wake boat on the application form. Now I stopped there. You're gonna ask, well, will DMV be able to do that? DMV said they'd be able to do that. And I thought when I read the email that they just said they could put the checkbox on here, but no, they say that they can put your home lake destination on the registration form as well. And remember, you get something that you're supposed to carry around with you that says what your home lake, what says you're registered. So you will be identified as a wake boat and you will have a lake boat designation on that registration.
Amazing.
And DED said they can do it. They need until the 28th to do it, but
Still, that's the fact that they can do it, I think is phenomenal. So,
but there is the question that I heard Kevin Burke say. How do you get that information to DEC if they're going to enforce the aquatic nuisance requirements and the decontamination requirements? I think you might have answered it that they either need to show proof on their registration that they are in their home lake or they have to show proof of decontamination, which you already have, by the way, in your reentry and transfer between lakes, they have to show proof of decontamination. So I think there should be an annual report from DMV to DEC so that they know how many wake boats there are and where there are lake boat, what their home lakes are. But I think Kevin's concern about proof is they either have to show that they're registered in their home lake, or they show that they have proof of decontamination from an agency owner, which you already have in the bill.
Can you say that one more time? Apologize.
All right, so there's two components. There's ANR's ability to enforce the decontamination. The one way they enforce it is you show that you are in your home lake and operating in your home lake. And that's on your registration. The other is if you're entering or re-entering your home lake, or going to another lake, you show proof of decontamination of your wake boat at an agency approved decontamination service. And then for ANR or DEC to get the information that it needs to inform its use of water rules or any other regulation, DMV annually sends the number of vessels registered as wake boats and the home lakes that are designated for those wake boats.
Okay. Questions? Yes.
Mr. Burks said, didn't he say that the home lake rule is not before I got?
In their proposed rule.
So.
Right, so it's in here, yeah. Okay.
And your statute, any statute, supersedes a rule that conflicts with statute.
Great. Okay,
So I have to make some changes to this language based on if you want me to make those changes. It's basically about submitting, having the resignation as proof of your home lake, and then the DMV sending DEC.
Mhm. Yes, I think that's a useful stuff, yeah.
All right, moving away from wake boats.
Yes, go ahead.
Michael, how does this intersect with out of state wake boat owners that are traveling in?
I think that's probably gonna be the hardest part of enforcement for the decontamination. Because if you can't show your resignation, your registration as your home lake, you're gonna have to show proof of decontamination.
Okay.
And that will be. That might be tense, because the language in here gives the greeters the ability to say to a person entering that they need to show proof of the decontamination, but as has happened in the past, there are sometimes confrontations between the greeter and the vessel owner or operator. They don't always agree. The bill says that the inspection station greeters are not law enforcement, and I think that needs to be clear that they're not law enforcement. But they are given the authority to announce that a vessel owner needs to decontaminate if they're a wake boat, needs to inspect, needs to dump their ballast, needs to, etc. They have that ability.
Yeah, okay, good.
I was about to ask a similar question, which is there anything we can do to make clear to somebody contemplating coming to Vermont for a week with their boat, that they must live with it or any other contamination? I understand that technically they're required to, but my guess is 90% of them don't know it. And so what can we do? Is there anything we can do Like, does a boat owner typically go on Vermont website and look at whether, what requirements there might be, or? How do we actually, because this is a major issue, is the out of state boat coming in, wake boat coming in and negating everything we're doing with our own internally. And just thinking about how do we really make clear to people it must be contaminated.
There's a level of reliance you're just gonna have to provide to the civil contractor. People
Trying to.
learn the law and try to comply with the law. I mean, I go back to Didymo and Rocksnot and like, there's tons of out of state anglers that come in to wade the streams, and as I said, I had just bought felt waders, and I was pissed. And and like,
What point those notice, so how can we make sure they really know it's required? Because it's hard to comply, even if you're doing it, but you don't really know you're supposed to.
right, I mean, there's the ways that typically this kind of thing would be done is the education and outreach, right? Media campaigns, signage, that type of thing. Like a signage at an access area.
That's what one thing I was thinking about.
Now, I had to go look at the new federal rules on access areas. There were some potential limitations on signage, but I don't think should be limited, but I need.
That's where my head went, was signage, but, if there's, but I know, Senator Williams had a comment, and then we'll go to Senator Hardy.
I was just thinking, that goes back to the definition, some states may already have decontamination stations that would be adequate to take it doing proof. We need to decide what we need to tell them they have to do it, so they can put it on the website.
Things, it seems like also for a lot of people, maybe not everybody, but they would be looking at, if they're coming to Vermont, do they need to buy a fishing license? Do they need to rent a cabin at the state park or whatever? So using our websites too, I mean, I'm just looking at the Department of Fish and Wildlife website. There's a thing about buying a license, and so maybe it's also requiring, and there's also a Vermont tourism website and things like that, so just requiring generally that relevant websites have information about it.
There's also the hunting and fishing rules in the guidance document that's issued with that, it's very instructive. And it's very readable and open to people.
So what kind of language could we use to have see all of the above?
I would say you wouldn't have a DEC do it, you have the secretary, which she has authority over all of them. And you would say something like to inform all users of state waters, including those accessing waters through the state access areas, of the requirement to decontaminate a wake boat prior to transfer to the water. That the secretary create signage for posting in state access areas to amend the agency website, appropriate places to provide notice. 3, amend the Fish and Wildlife handbook, I can't remember its exact name, that's what I call it, handbook, to inform those persons to provide information within the handbook of the decontaminate wake boats. And then whatever else you sold.
Mm-hmm.
Good job.
NASC is the National Association of Legislative Sportsman Caucuses. They do an annual bulletin, many changes in all 50 states. And, we have a sportsman office, and what is. So we can put that out, make sure that it gets to the sun there.
Are you thinking that we need language to put that together? So, okay, yeah. Great,
Okay,
okay.
so moving on into the access areas language, the chair directed me to meet with the department to see if there was any way to come to some sort of consensus on the use of access areas by inspection stations. And you will see on page 12, line 4 and 5. This would basically, the concept here is instead of inspection stations being an always authorized use of an access area, unless they interfere with another use, that the inspection station needs to be permitted by the commissioner in order to use that access area as an inspection station. So the commissioner will be able to make determinations about whether or not the size of the access area is appropriate, whether or not the environmental site conditions are appropriate. So effectively, there would be a permit for the use of the access area. And the commissioner could establish conditions in that permit for use of the access area. It would still require, if there was interference with the authorized use of the access area, that the inspection station would need to relocate or stop working until the interference was resolved. I think this is consistent with the federal rule. I think whether or not you want to permit an inspection station is something that you, the General Assembly, State General Assembly can require. And whether or not you make it a use at an access area, but you will have those concerns that the department issued about physical control, lack of site conditions, etc. It's not gonna make everybody happy. Just so you know that. So there will be access areas where people want an inspection station and the commissioner's gonna say no. Just.
Yes, go ahead.
Well, what we want, I think, is for stations. But within, I understand the conflict with the federal review, so we have to world that, but otherwise, I think that we want the stations for more places in the future, and we want contamination to take priority over parking. So I understand the issue of the federal rules. I don't understand it, but I know it's there. So I sort of like maybe permitted, but it's priority for the possible.
So I think parking is the issue that creates the most conflict at access areas. But I think you heard from the department that it's not always parking, it's not always the size of the access area, it could be the site conditions. And the one that seems to be the attention getter here is Joe's Pond. And how DEC doesn't want to allow the inspection station because of the runoff into the wetland. And the Department of Fish and Wildlife doesn't want to allow it because of the size. How do you say that they have a priority on that?
Yeah,
I don't know.
and we don't want to.
Yeah.
Off into wetlands or, back into the water. So.
Does.
Yeah. Good.
Very good. Testify,
Yes.
remember?
Joe's
This-
Pond.
and he had a couple of language recommendations. I don't know if you recall that, Michael, if you're in the room, but I'm just wondering if are they incorporated into this in any way?
I don't
Okay.
think I ever saw his direct edits.
Was his about the access areas? I thought.
This is, yeah, it's specific to access areas and parking versus both.
I did see some recommendations to move inspection stations all the way to the top of, as the priority use underneath the access area rules. And I think that would create conflict under the federal rule, because we're supposed to use the access areas for their authorized use in their grants. And none of the grants have specific authority for inspection stations. It's just that the rule is broad enough to allow inspection stations, but they're not that authorized use. And remember, these grants have been awarded. Because some of them, the initial grants are 50 years old, not older. So the concept of inspection stations, probably not common. And so you're not going to see a lot of the older access areas with authorized uses that specifically say inspection station. So that will mean that the fishing and hunting and motorboat use will always be potentially the priority.
Yes.
Bottom of page 12. It's not the highlighted stuff, but I don't remember section, the paragraph 3, A and B. What does this mean?
So there's already a provision in law
Yeah.
that says when you are leaving a water, that you need to drain your vessel, except for your live bait.
Yeah.
And you need to inspect it for aquatic nuisance species. And so this is just referencing that.
The section, paragraph 3.
Yeah, so this section and the rules adopted under it, the use of the access area shall not be construed to mean that a conflict exists between the aquatic nuisance inspection station and a higher priority use when an operator of the station informs the user that they have to decontaminate their rate boat or inspect the vessel for aquatic nuisance species.
Okay, I think I don't understand. Shall not be construed to mean a conflict exists. Is that a concept in the?
It's a concept underneath the state's access area rule.
Okay, so if somebody says there's a conflict here, the higher priority gets the priority if they identify a conflict. So this is saying no conflict exists.
Right.
You can't say my fishing boat access is a higher priority, so I'm not gonna drain it.
I don't think you were in the room earlier when I referenced that there has been tension before between greeters and users of access areas.
Yeah, no, that's come up a couple times actually.
When a greeter says, hey, you can't be using this water because you didn't decontaminate or you didn't do your inspection. I could envision certain users calling the warden saying the inspection station is conflicting with my priority.
Right, okay, that I understand it now. I just did that phrase, there shall be no conflict with priority use. I didn't quite understand what that meant. Okay, yeah, I mean, I'm concerned about that conflict too, and I brought it up. There was a witness we had. It was like, oh, the greeters can just enforce this, and I was like, wait, no, they're not law enforcement.
Not law enforcement. They're authorized in this bill and elsewhere to say, to notify people, but that's where their authority ends. If somebody is going to disregard that notification and enter the lake or exit the lake without drainage, it's not the greeter's responsibility to enforce it. They should notify a warden. These are DMV offenses. You can call the state trooper or your local law enforcement. They should have authority to enforce that. They don't, they won't show it. The wardens will, but they might take time for the warden to get there.
Yeah. Okay, I just want to also recognize that it's 11:30. We have other folks wondering about if we can put a pin in this
Sure.
and come back and finish the walkthrough on this
So,
another time. 'Cause I know there's not a lot left, but
no, there isn't, but I just I'm gonna, in an outreach and education program that the Agency of Natural Resources is gonna do for wastewater contamination. I'm gonna make the wastewater registration proof of your ability to operate your wastewater in compliance. Or you show your decontamination. And then annually DMV sends the EEC the information on wastewater and home lake designation.
amazing. Oh, a couple comments, Senator Williams and then Senator.
No, I'm gonna offer, would you like me to give a definition for a decontamination thing?
Oh, yeah, so it needs to go.
Oh, yes.
with the-
Definition,
Yes, thank you.
yes. And then some.
Just say quickly, we also, when we're doing that education for all the mechanisms that the secretary is going to use, we should also include the obvious which lakes they can and can't go to. Very good.
Great. Okay, any other questions at this point? So we'll continue with that walkthrough later on, right? Thank you so much. Okay, all right, so we are moving to a topic we haven't talked about recently, as 247 about plastics. So we're gonna start with Jonathan Beaker, welcome. Or would you like to start
Is it
with?
possible Flora could go?
That is perfectly fine. We can start with Ms. Gillian, who is speaking to, I believe, the DHP part of this. So just to refresh our memories, there's 3 sections to this bill. The part that I am especially interested in talking about this morning would prohibit a certain kind of plastic, DHP, in for example, medical IV bags and other medical type products. So just focusing in on that part of it for now. And so Ms. Gillian with the Breast Cancer Prevention Partnership, welcome.
Thank you so much. Good morning, all. Chair Watson and members of the committee. My name is Laura Gillen, and I'm the Senior Program and Policy Manager for Breast Cancer Prevention Partners. And I'm here to testify in strong support of S247. As a former toxicologist and a mother of 2 children, I applaud this common sense legislation. It is a vital step towards phasing out DEHP in medical devices and addressing the broader crisis of plastic toxicity in our consumer products and waste streams. S247 ensures that medical devices do not expose patients to DEHP, an extremely toxic phthalate used to soften PVC plastic. Because DEHP is not chemically bonded to the plastic, it leaches directly into the fluids, nutrition, and air being delivered to a patient's body. As a toxicologist, I want to emphasize that DEHP is a known endocrine disrupting compound. It is linked to breast, liver, and lung cancers, as well as reproductive harm. Perhaps most concerning for our work at BCPP is that laboratory studies show DEHP can actually promote breast cancer cell growth and reduce the effectiveness of chemotherapy. These devices can undermine the very treatments they are intended to deliver. Most people would agree it simply does not make sense for a medical device to contain a chemical that interferes with healing a patient. We understand there may be requests from trade associations to limit the bill strictly to intravenous tubing. However, I must urge the committee to maintain the current language that also covers enteral or feeding and respiratory tubing. Toxic exposure does not stop at the vein. Peer-reviewed research from as recently as 2024 and 2025 confirms that in respiratory therapy, air is often heated and humidified, and this heat causes DEHP to volatilize and hitch a ride on water droplets directly into the lungs. Studies have found that used endotracheal tubes contain significantly less DEHP after use than before, meaning that the chemical is leaching out of the tubing directly into the patient. DEHP is highly fat soluble. The lipid-rich formulas used in feeding tubes act like a magnet, pulling DEHP out of the plastic walls. To exempt these devices would be to leave out our most vulnerable patients, including infants in the NICU, unprotected during their most critical stages of development. Vermont is not alone in this effort. BCBP sponsored California's AB 2300, the first state law of its kind, enacted in October 2024. North Carolina followed 6 months later, and similar bills are moving in Washington and being introduced in New York and Michigan. This flurry of activity reflects a deep medical consensus. For over 20 years, major agencies and medical associations have encouraged healthcare providers to consider safer alternatives. In 2002, the U.S. Department of Health and Human Services highlighted the risks of DEHP in medical devices, and the California EPA has classified DEHP as a Proposition 65 reproductive toxicant. Major organizations, including the American Medical Association and the American Academy of Pediatrics, have urged hospitals to reduce and phase out DEHP containing PVC. This is especially urgent given that FDA-approved safer alternatives have existed on the market for over 4 decades. Beyond the hospital bedside, 247 addresses the health risks of plastics at both the beginning and end of their life. By expanding the ban on plastic microbeads to include cleaning products and non-rinse-off items like sunscreen, Vermont is closing a loophole that allows trillions of microplastics to enter our bodies, water streams, and our food chain. And Section 1 of this bill is a critical safeguard. So-called chemical recycling or pyrolysis is a high-heat, high-emission process. From a public health perspective, these facilities often release the very carcinogens we are trying to remove from consumer products back into the air of surrounding communities. So this is a good bill that could be further strengthened by banning PVC in addition to DEHP in medical solution containers in Vermont to protect communities from this poison plastic, which is toxic at every stage of its life cycle. However, as written, it's a massive step forward for public health. So on behalf of BCBP, I urge you to support this important legislation and respectfully ask for your yes vote on S247. Thank you for your time and for the opportunity to testify today. I'm happy to answer any questions you may have.
Great, thank you. Any questions? Okay. All right, super. Well, thank you so much. Really appreciate that. And if you have a written testimony, if you could send that to our police. And all right, so we're gonna move from there to, so should we go to Ms. Jones from Beaufort? Welcome.
Thank you. Hello, Chair Watson and members of the committee. This is actually my first time testifying, so thank you for the opportunity to introduce myself. For the record, my name is Alexis Strown. I am an environmental associate at the Vermont Public Interest Research Group. There, I work on a number of waste issues, especially those regarding plastic and its consequences. I think even in divided times, most people generally agree that there is way too much plastic, especially single-use plastic waste. This is an issue that really resonates with Vermonters. We see that reflected in the laws that have already been passed out of this legislature. For example, Act 69, some people call it the plastic bag ban. It was also the country's most comprehensive single-use plastics ban at the time. And just one of the benefits of that law, we estimate it's eliminated at least 864 million bags since being passed. We live in a state where people really value the natural beauty of our environment. As a lifelong Vermonter, I grew up in Tilton, Vermont. I grew up around with compost bins and community gardens and other childhood dialogue about my carbon. I truly believe that the battle against plastic pollution hits on our core values here. Just to put that problem into perspective, over 450 million tons of plastic are produced globally every year, and less than 10% of that is typically recycled worldwide. That's a lot of plastic, but not as many people know how much of it is now
Plastic is choking our environment, and people often don't know how toxic much of that is. Fact is that plastic isn't naturally biodegrading, it's just breaking up over time into smaller and smaller pieces. Toxic plastic chemicals and those little bits of plastic called microplastics then get into our water, our air, our ecosystems, eventually into our bodies. So the science right now is making us aware that plastic's no longer just the litter issue we once thought it was. It's a lot bigger than that. And Vermont's not immune to any of that. Plastic is everywhere. While Vermont has made progress in a lot of ways, chemicals that have been linked to reproductive and developmental harm, neurodegenerative conditions, cardiovascular problems, even increased risk for certain cancers. Those chemicals exist in the plastic that we're all using every single day. There's also, microplastics in Lake Champlain, our consumer products. They're in, like Laura said, they're in our air. This is really, really scary stuff. But as I've noted, Vermont is a place where we've already begun to take action. I think right now it's time to take another really important step. So that brings me to S247. I think this bill truly navigates the moment that we're in right now. Administrative agencies have limited capacity, the funding is difficult. Common ground can feel really hard to find, and the strength of S247 is that it doesn't create major administrative burden. It's not really expensive to implement. Each provision represents, a tangible step forward for a problem that we're all seeing every single day. What the bill does ask for is a small amount of additional accountability from producers because they know their products the best. They have the most control over how it's marketed and over what's in them. For many of the questions before you, we can look to other states and the conversations and compromises that have already occurred, and we can see that these steps are taken. So, S247 does not require Vermont to fight an insurmountable battle right now, because they're modest steps and they're steps that we could take. So to dive more into the specific provisions, there are 3 provisions in this bill. The first is on chemical recycling. Chemical recycling, as we know it today, simply doesn't work. The data is telling us that when these facilities chemically convert plastic with these heating or burning technologies, the main output that we are seeing is fuel. So many of these technologies are very similar to incineration, it's just under a different name. And that's important to know because the facilities built to chemically recycle plastic are also incredibly expensive. They rely on a lot of public subsidies, and by every standard that we have, they are horrible for the environment and the health of surrounding communities. In Vermont, we've historically said no when we see things that are bad for the people and bad for the environment. Even if our state isn't the main target for a facility like this, I think it's worthwhile to make clear that this law technology isn't right for Vermont. And Vermont's already taken similar action with things like fracking and trash incineration. So this legislation would protect Vermonters by recognizing chemical recycling for what it actually is, which is dangerous, deceptive, and ultimately really ineffective. The second provision, which you all just heard about from Laura, is DEHP in medical devices. Like she said, this is a phthalate. It's used to make PVC more flexible. It's also incredibly toxic. And since it's an unstable chemical, that means it is leaching into the environment and it's leaching into patients. I think there are good reasons why DEHP should not be used in medical devices. First, of course, it's just the threat itself to human health. That's why other states have already taken action. California and North Carolina have passed very similar laws. Major manufacturers already produce DEHP and PVC-free alternatives for all IV bags and for certain medical tubes. So that means that the manufacturing capacity right now is already expanded significantly. There are also multiple companies that are willing to testify in support of this bill because this change is imperative for people's health, our environment, and it can be cost effective as well. However, without a reason to shift that market in our region of the country, do we really want to assume that, it'll just happen? So this provision ensures that Vermont is not left behind in an important market shift that prioritizes public health. The third provision addresses microplastics. Microplastics, some of you might already know, really are everywhere. There seems to be a new headline every single day. And we know that they're harmful. Microplastics cross party lines. I think few people got that they're a problem right now, even the federal government. Question is, what can we do right this second? So the bill in front of you has a modest expansion of an existing federal law by banning microbeads or non-rinse off personal care products and. So microbeads are commonly understood to be a specific subset of microplastics. That's how they're defined federally, that are intentionally added to products to provide abrasive or exfoliating properties. There's also already viable and affordable alternatives. We saw California make significant progress in addressing the issue of microplastics through a recent bill called AB 823. That bill was passed in 2024, and while it ultimately did not become law, advocates and legislators engaged in really extensive conversations with the industry. And they largely reached a compromise that would regulate this specific subset of microplastics in these products. So it's important to note that the scope of this legislation, as it appears in the bill before you, was generally accepted by various stakeholders, given the health concerns associated with microplastics. Broader regulation will obviously always be really important to consider, but this represents something really tangible and a useful step forward that we can do right now. So in closing, this bill, S247, is about providing those tangible solutions to the very real problem of plastic pollution, and it does not and cannot solve every single aspect of the problem, but it is meaningful and worthwhile, and we strongly urge you to support it. So thank you for your time and for considering S247. With that, I'm happy to answer any questions.
Do you have any questions at this point? Anybody has some questions? Okay, right.
Thank you so much.
Well, thank you so much. Okay, and I think that is it for the day. So if there's no other questions or comments, anything folks want to say just generally, or anything you've heard so far?
On this.
Or this,
247?
247 or anything else?
I need to hear from businesses and industries, I think.
On this.
Yeah,
Mhm.
I think the hospital.
Yep.
Industry is. We make sure that we don't make their lives more expensive.
Yes, yes, fair enough. Yep.